Good morning, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. Now, first things first, real quick, before we get started, as always, you will see the document that is shown in this video in the description box. What you'll also see is the very first video that I have made since the lack of technology one that was made early last year or mid last year. It was about around this time. Neither here nor there. The video that started this barrage in regards to JRC, you'll have to watch the whole thing all the way through the end to figure out why we are covering this case on this channel so heavily right now. Also included is the Change.org petition to shut down the Judge Rotenberg Center. If you haven't already signed it, please do. Please share it on all your social media platforms. Right now, the petition is really struggling, and I believe we're still below the 1,000 mark. I could be wrong. I haven't checked it in a minute. But please, the more that sign that petition, the better. Also, real quick, when we are discussing the JRC on this channel, you will see in a good majority of these videos vivid descriptions and depictions of the abuse and torture of people with disabilities. So, if you have any young children present, please don't forget to have headphones on you. Also, it is 5:54 a.m. in the morning, folks. I am barely awake, and I am contemplating against my better judgment whether I should go ahead and have more caffeine. So if I horribly mangle any legal jargon or terms, or if I stumble over my words, please, I ask for your forgiveness in advance. All right, folks. Without further ado, we are starting on Section D this morning. This is the litigation history. And folks, we are covering the legal documents for the Judge Rotenberg Educational Center, Inc. versus the U.S. Food and Drug Administration. So let's go ahead and get started. The FDA has now produced over 24,000 pages, largely spurred on by the plaintiff's instant lawsuit. Indeed, from the plaintiff's submission of 4 FOIA requests between July and December 2nd, 2016, to their initiation of this lawsuit in October 2017, the defendants have released only 92 pages of records. Shortly after the plaintiffs filed their complaint, and after the court instructed the parties to propose a briefing schedule to govern proceedings in this case, Minister ordered December 2nd, 2017, the defendants started releasing records to the plaintiffs as described in SPURA Section IC. Yes, because the FDA doesn't monitor over 1 million different other things for all 50 states, so they should just really addy up all those documents before, actually going over them with their lawyers. Okay, Chad and Karen. By January 2018, the defendants claimed that all FDA divisions under the CDRH, which had not yet started releasing responsive documents, had responded in full to the plaintiffs' FOIA requests. See Sublime Joint Meet and Confer Report at 8 ECF number 16, a plainly erroneous claim given the production subsequently made throughout 2018. That's because, folks, wasn't the freaking FDA that was under the microscope. It was you. The documents that they forced you to cough up had nothing to do with this particular lawsuit of yours and everything to do about the possible ban of the GED 3A and 4 devices that they never approved for you to use in the first place. So, if they weren't even being countersued back in 2017, why in the name of hell should they have had to produce these documents you are demanding in 2019? Are we sure these aren't AH's lawyers? Because, God, it's the time traveling thing all over again. At that time, the CDRH estimated that its search had uncovered roughly 60,000 pages of records responsive to the plaintiff's requests. The apparent semi-complete nature of the production was too great an obstacle for the parties to agree on a schedule to govern proceedings in this case, prompting the need for a status conference to accomplish that case management task. Following the February 2, 2018 status conference, the case was bifurcated. CDRH and any other HHS component to which a referral has been made were ordered to make a rolling production of no fewer than 5,000 pages per month on the plaintiffs beginning on March 1, 2018, and continuing every 60 days thereafter until the production is complete. Wow! Thank you, Massachusetts Court, for proving you're just as corrupt and stupid as the UK. I appreciate it. Yes, let them time travel to 2018 and just magically produce something for a court case that at the time did not exist. Separately, the court entered a scheduling order setting a deadline for other defendants to file an index of documents withheld full or in part, known as the Vaughan Index. See Vaughan versus Rosen. And deadlines for the parties to file positive motions as to issues arising from the responses by each FDA component after the CDRH. Defendants filed their first Vaughan Index by the initial date. By agreement of the parties, however, see Joint Mont Revised and Extended Scheduling Order ECF number 20. The scheduling order was modified to a new deadline for an updated Vaughan Index and filing of dispositive motions. After additional extensions, the defendants moved for partial summary judgment and provided an updated Vaughan Index. That index, totaling 1,929 pages, gives a Bates stamped number, description, date, author, recipients, the basis for withholdings, and the number of pages fully withheld for all records withheld in full or in part. The index confirms that the defendants have withheld records under the 3 FOIA exemptions. FOIA Exemption 5's deliberative process privilege and attorney-client privilege. Oh, how horrible that they withheld documents that would have done away with attorney-client privilege. How awful. Jesus Christ. Exemptions shield for personal, medical, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. Thank you. It's called HIPAA law. And exemptions protection for law enforcement records that could reasonably be expected to constitute an unwarranted invasion of privacy. Amen. A narrow category of records implicating personal privacy interests in Exemption 6. After the plaintiffs filed their cross motion for summary judgment, the defendants filed a third version of the Vaughan Index, 50 pages longer than the prior version, which corrected some problems that the plaintiffs had identified. That index is 1,979 pages, and like the prior versions, gives for most withheld documents a Bates stamp number, a description, the document's date, author, and recipients, whether the document was withheld in part or in full, the basis of any withholding, and the number of pages fully withheld. The parties' cross motions for summary judgment are now ripe for resolution. The plaintiffs have scheduled a hearing, but that request is denied as unnecessary given the voluminous record of this case. Oh, thank God the judge not completed yet. Okay, so basically here, this is documents. Those in the JD supporters community, we've heard terminology like this before. JRC is demanding everything but the kitchen sink, and the FDA rightfully is denying any document requests that would violate attorney-client privilege, that would violate HIPAA law, and violate anything that might compromise the safety of the folks who had testified. They are protecting private information, folks, and yet the JRC was demanding that they turn it over anyway. This is an intimidation tactic, folks, not just against the lawyers of the FDA, but those who made the possibility for the FDA hearings to happen in the first place. They are trying to dig into these folks, to dig out and throw into the public eye the medical documents and records of vulnerable people. It's a disgusting thing to do. It's very much they want to A, intimidate all these witnesses and those who testified, and B, use it as a means in which they can point the finger at them and say, see, they needed the shock. See, look at their records. They're horrible people. They hurt people. They hurt themselves. We must treat them like cattle and shock them to death, or they'll be a danger to themselves and society. Yeah. These people are really that freaking disgusting. As if we didn't already have proof to the level of their sick depravity. So, now they're badgering the FDA for documents that they have no legal right to with this particular motion here that you just saw me read. Surprise, surprise, right? It's not just intimidation, it's also a waste of court time and resources. It's really messed up when you're going to waste money on lawyers just so the judge can tell you, no, we will not violate attorney-client privilege. We will not violate HIPAA. We will not violate the privacy one should expect when talking to the police or any other type of officials. So, yeah. You can't use this in order to intimidate the FDA or anyone else. And why you think there's even a smidgen of hope, JRC, that you could ever intimidate a federal agency? I don't know if you're brave, stupid, desperate, or what. But there we are. So, folks, I'm going to make this relatively short this morning. And, I was going to throw in an unrelated Foamy the Squirrel video, but check out Ill Will Press, folks. I want to save this starting on the second part, legal standard, for tomorrow. So I'm going to go ahead and head out. As always, folks, we don't get very many views on this channel. The few that we do tend to get removed from time to time. So if you be so kind, folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. I do appreciate your time this morning. As always, we here at Spilling Tea hope you have a good one. Bye-bye.